Today's Truth and Reconciliation Day, so I think today it's really important to think in the context of law, since I'm a lawyer, how we incorporate the findings from the Truth and Reconciliation Commission into our work in law, and how we conceptualize justice in a way that factors in colonialism and the fact that our legal system is in and of itself colonial. How do we reconcile that? How do we ensure that Indigenous life, Indigenous culture, and colonialism and the impact that has had on Indigenous communities is an absolute consideration in all legal cases that are before the courts and tribunals in Ontario and Canada? This is my attempt to look at how we might be able to move forward and incorporate some of the findings and concepts more broadly of colonialism. So even where lawyers aren't directly involved in Indigenous law, which is me, I do mostly human rights and employment law, there are still many ways in which we can incorporate the concepts of colonialism, but also all of the findings and recommendations from the Truth and Reconciliation Commission. I believe we have a duty to educate courts, judges, other lawyers about the impact of colonialism, and that also factors in the impact of trauma and intergenerational trauma that is carried over from one generation to the other because of how deep rooted it is and how impactful it is, and how that impacts the whole society, as well as the systemic barriers and discrimination that exists for those populations. So even though we're looking forward, we're talking about the history and the impact that that has had on this group, these Indigenous people who were here. This is their land that we are sitting on and using, and we need to make sure that that is really a part of all of our discussions as we think about what justice means. So in the context of human rights law and working at the Human Rights Tribunal, I see this as being talking about the impacts both of trauma and colonialization on individuals, on Indigenous people specifically, and making sure that we're arguing for something called the intersectionality of discrimination. So this is applicable to absolutely every case. We don't experience discrimination and wrongful treatment or harassment in silos. I don't experience that just as a woman. I experience it as who I am as a mother, an employee, an executive, whatever my makeup is. It is all of my identities, my age, my social constructs, where I live, how I operate on a day-to-day basis. We aren't just one piece, we are many pieces. And that goes for people who've experienced trauma, persecution, and are also facing systemic barriers, systemic racism, systemic discrimination. That all has to be encompassed in any discussions as well as decisions that come out. And the more we push that forward, the more we're going to see that in decisions, which we can then rely on future cases. So a few final thoughts. I think that we need to rely on published cases as well as published articles and research has been done by the Indigenous community and others who have expertise in this area to talk about the impact of colonialism, what colonialism is, and then bring that into our legal arguments so that it is forthright in all decisions. And then we can start to see this thread weaving through as we reconceptualize justice. And obviously this isn't something that we need to just do today. This is something we should do always, and something that I commit to learning more about and figuring out how I can implement in my day-to-day work as a lawyer, and making sure that I'm putting these concepts into my legal arguments, because that is, I believe, the best way to advance the law, is by infusing this information into the justice system through legal argument and then vis-a-vis the final decision that the judge or the tribunal adjudicator writes.